Yes, yes. May I pray for listing of an old matter, my lord, 2017 matter for hearing, my lord. If it is possible on 27th, and
Let it come for orders first on 28th.
28th.
We'll fix a date after that.
Yes, yes, yes.
Keep
Obliged.
it for orders.
Yes, madam. Obliged.
Meet this, my lord. This matter may come up on this Friday, 21st.
Why?
My lord, this is an urgent matter for pension matter. The PF and all the gratuity is being paid, but the pension is not being paid till date.
24th.
20.
Yes.
May please, your lordship. Lordship, may these letters be, cases be listed in the next week, lordship?
For admission.
Lordship for orders, lordship.
For orders.
No.
24th.
24th, lordship. Obliged, lordship.
Lordship, I'm praying for listing of two matters, Lordship. Tomorrow, Lordship, we have filed an interlocutory application, Lordship. The petitioners are suspended employees of the SBI and without any review of the suspension order and without service of charges of.
Why tomorrow?
Because, Lordship, yes, Lordship, because regular hearing is being conducted now, Lordship, from 18 November to 21st of November, departmental inquiry. We are suspended, Lordship, without any review of the suspension order and without service of charges of memorandum of charges, Lordship.
No, I have not understood. You are filing an IA seeking orders.
Seeking, keeping in abeyance this regular hearing of this departmental inquiry, Lordship.
Why?
Because, Lordship, our suspension order has not been reviewed and charges,
Is there
Have
a
a-
criminal case pending?
no, Lordship. The prayer on interim relief was also kept open, Lordship.
Let it come on Friday?
Lordship, tomorrow, Lordship.
No, tomorrow. Why?
Or day after tomorrow, Lordship. Because
Day after-
21st is the last date of regular hearing, Lordship.
Day after tomorrow. Today is
Lordship.
Wednesday.
Yes, Lordship.
Day after tomorrow.
Yes, Lordship. Obliged, Lordship.
May it please, my lord. Prayer for withdrawal of one matter, my lord.
Tomorrow.
My lord, one more prayer, my lord. Prayer for listing of a matter in the admission column, my lord, pertains to family pension.
24th.
24th, my lord. Deeply obliged.
May I please, your lordship? My lord, item number 24, my lord. This order has been complied, my lord.
Huh?
Item 24, my lord.
Order complied.
Order complied, my lord.
Mr. AHMR Chaudhary, Direct Counsel to the petitioner on inspect submits. The directions contained in the order dated so and so, passed in WTC so and so, has since been complied with. The petitioner therefore does not wish to press the petition any further. Contempt petition any further. Taking in court's direction for submission. Court considers it appropriate to close the proceedings at this stage. Contempt petition disposed of, notices issued are resolved. Who's for the respondent?
More Pujari, my lord, he's.
Mr. R. Pujari appears for the respondent.
My lord, another prayer, my lord. Item number 35, my lord. Supplementary, my lord.
We are dismissing it.
My lord, I have the instruction to withdraw this hearing.
Item 35 on the instructions received. The petitioner does not wish to press the writ petition any further. Accordingly, the petition stands dismissed on withdrawal.
My lord, I have another prayer, my lord. For listing of a motion matter, my lord. Motion matter, my lord. Day after tomorrow.
Listing of
Motion matter, my lord. Day after
motion,
tomorrow.
new motion.
New motion.
When was it filed?
My lord, last Monday.
Last Monday.
Monday.
All right. Press motion, yes.
Obliged.
Lord, item number 15 is a part 2 matter. Part 2, my lord, bench 2 matter.
Item number
Item number 15.
15.
Yes, 15. But wrongly listed in this course, so my lord, may be placed before the appropriate bench
15.
on 21st, my lord.
We can only say the matter be listed by the registry. Fixing a date may not be correct,
Okay.
but it is shown to be a bench 3 matter.
Yes, yes. But it is a part, bench 2 matter, my lord. Education department.
Why is it a bench 2 matter?
Compassionate appointment case laws. Sentence the SOP lordship
Then-
3825.
Why is it a bench 2 matter? It is a bench three matter. Somebody misinstructed you.
Then
You wait for the matter to be called up.
Yeah,
Yes.
please, Your Lordship, I beg to mention supplementary item 42.
Hmm.
We could not obtain instruction as the principal secretary is also newly in the office and we are working on the court's order to comply, Lordship.
Who's for the petitioner?
Lordship, I am for the petitioner.
Short accommodation.
Item 42 on the request made by learned counsel for the respondent, MS so stands referred to be listed after 3 weeks,
Lordship, not 3 weeks.
enabling her to complete the instructions. How much time you want?
Short accommodation 2 weeks after.
2 weeks. Mr. P. Bordola is for the writ petition.
Can a date may be given?
All right, Lordship.
Can a date may be given? Lordship?
12 December.
Lordship.
All right, Lordship.
Oblige, your Lordship.
Maybe Lordship, I beg to mention for listing an IL Lordship for stay repeating petition Lordship. Appointment of governor Lordship.
Next Monday,
Oblige.
24th.
May it please your lordship. Your lordship, I beg to mention one writ petition for listing in the orders column.
Orders column, 24th November.
Obliged.
Motion, Lordship. Petitioner is going to termination from his service on last
When did you file the motion?
motion filed on the last 12th, Lordship.
12, all right, Friday.
Obliged.
Yeah.
I'm praying for listing of a case for admission, my lord, on Monday, my lord.
Monday,
Yes, my lord.
all right, Monday.
Oblige.
May I please your lordship. Lordship, I beg to mention for listing lordship in admission column lordship.
What is the matter?
Matter regarding termination of the service lordship.
28th November,
Well, I also have same prayer, my lord.
28th?
before 25, my lord, because December there is a problem, my lord, the appointment will be given. So before that,
24th?
24th, my lord.
Yeah.
Bless.
May I please your lordship? In this matter, your lordship, one IA is filed for implement.
You have
of
not filed?
Yes, already filed.
When?
On 7/11, your lordship.
7/11?
Yes, your lordship. One objection was there, but it was already cleared.
Right, office note dated 15/11/25 reflects that application for implement as permitted to be filed with the petitioner has not been filed. There are Mr.
A Hussain, your lordship.
A. Hussain, counsel for the petitioner submits that the IA has been filed on
7/11, your lordship.
7/11. Stop. However, no IA has been placed before the court. Office to verify, registry to verify. And list the IA along with this writ petition. For orders. Immediately. After 1 week. Mr. N. Upadhyay for the respondents.
1 to 5.
Respondent 5.
1 to 5.
One.
1, 2, 3, 4, 5.
Yes. You are for?
Item 20, Lordship.
Huh? Mention is over. Yes.
Obliged.
Correct. Counsel for party.
May it pleases your lordship, this contempt petition has been filed for non-compliance of the judgment
Yes,
and order.
counsel for party, we should notice. 4 weeks. The petitioner will take steps by registered post on the respondents within 1 week from the list after the 24th date.
Deeply obliged.
Item 3.
Non-compliance of the order, my lord. Division bench also has also dismissed the case. But what I pray, my lord, your lordship will kindly follow this content rules. Because yesterday I was looking into data, about 800 my lord, content cases in a year. So the core rule says, my lord, whenever the High Court issues a notice, if it sees reason to do, so do dispense with the personal attendance of the person charged with the contempt and permit him to appear. In cases, my lord, your lordship may dispense it, but in cases, my lord, here, single judge has passed that order, they went to division bench, dismissed the case. Yet, my lord, the order has not been followed. So I pray, my lord, your lordship, kindly following this order, their personal appearance may not be dispensed with.
No, first let us understand their views. If they
Yes.
don't respond, we'll pass appropriate orders.
But your lordship will kindly see page 16 is the order passed by this court.
That's right, but we'll have to
Yes,
issue them,
yes,
nobody
yes.
is there.
Yes. Because by the time it comes, the officer gets changed. Then another officer comes, we are required to make them party again. It's
Oh,
putting
this is
justice.
that,
This is-
news.
My lord,
What benefit was there? State information.
yes.
Heard counsel for parties, counsel for the petitioner. The petition is filed by alleging willful disobedience of the directions contained in the order dated 28/6/2024, passed in WPC number
Division bench just dismissed on 21/8.
5578 of 2023, which order also came to be upheld, confirmed by division bench of this court by the order dated 21/8/2025, passed in WA 357 of 2024. Stop. It is submitted that in spite of the orders of this court, in spite of the orders of this court, the directions contained in the order have not been completed. Therefore, has approached this court, issue notice, which are every 3 weeks. Steps by registered post. Within 1 week from today. Do you want to take Dusty?
Dusty, your lordship?
You want to take?
Yes.
Petitioner is also permitted to take service by Dusty routed through the registry of the court. Matter be listed on twelfth.
12/12.
Will you please read it?
Deep level.
12 December.
Deep level.
Item 4.
May I please, your lordship. Lordship, the petitioner was engaged as GIS assistant, Geographical Information System Assistant, on contractual basis, lordship, pursuant to an advertisement and a selection process. Now, lordship, these works are continued under this Basundhara scheme, lordship. While the scheme is still in operation, works are still continuing, and others around more than 100 all over Assam are still continuing. I have been disengaged on verbal order, lordship, on 18/4/24. Now, lordship, on the last occasion, respondents, I had made a submission that I will give up all my past claims, lordship. So this honorable court directed the respondent to seek instruction whether I can be continued.
They have considered the entire things, lordship, and lastly they said he is not suitable for employment under the office.
I think you should bring it on record
Okay, lordship.
so
I'll
that he
bring.
gets an opportunity to.
Lordship.
But notice has not been issued here.
Hmm.
So we'll keep it at the motion stage, let him file,
Lordship. Lordship, then I
we'll
shall.
decide.
Notice was waived, lordship.
Huh?
Notice was not issued. There is an order that notice is waived. Page order dated 28/3/25.
23/25 issue notice was there, I think.
Huh?
Notice was there.
Issued.
23.
Why
Issued,
is it for motion then?
Yes.
Matter be listed for admission, MS M. Bhattacharya, learned government advocate, has placed before the court the instructions received. She would, however, like to bring it on record by way of an affidavit. The learned counsel, the government counsel is permitted to bring on record the safe instructions by way of an affidavit list on, can we have it on 3rd? 3rd December?
3rd December. Okay, lordship.
3rd December.
Obliged.
Mr. J. Hendik for Revenue Department.
Obliged.
Deeply obliged, lordship.
Item 5.
Lordship, in this case, Lordship, I am today I am going to file my affidavit, Lordship. But Lordship, kindly fix the matter on admission column. Lordship, notice already issued, Lordship.
Notice issued.
Yes, Lordship. On 10/09/2025.
By order dated 10/9/2025, notice has already been issued.
Yeah.
The respondents, counsel for the respondent, veterinary department.
Lordship.
Mr. J.K. Goswami submits that he would file the affidavit during the course
Today,
of the day.
Lordship, today.
So, Mr. Chaudhary, Fukan,
I'm for the JAD, for the respondent.
are you filing anything?
I don't know, we are a formal party.
Right. Mr. A. Fukan appears for JAD. Let the matter therefore be listed again on 8th of December
Lordship, the name of the SC
for admission.
yeah,
Since
Lordship,
notice has already been issued.
name
Names of all councils, including SC,
Animal Husbandry and Veterinary Department.
Veterinary
Lordship.
Department and SC GAD
JAD is already there.
be reflected. In the process by the registrar.
Right. Then see.
Lordship, affidavit has been filed from the end of the district commissioner yesterday, Lordship.
Oh.
It has not come on record, Lordship.
Who has filed it? Respondent.
Respondent number 8,
Eight,
Lordship.
Lordship.
It is submitted that the respondent 8 has already filed an affidavit yesterday. However, the same is not on record. The registry to trace out the said affidavit stated to have been filed and have the matter listed again after 1 week.
Obliged, Lordship.
I am appearing for 2, 6, 7, 8 and 9.
MSS for respondents 2, 6, 7, 8 and 9. Mr. J. Hendik for
3, 4 and 5.
3, 4 and 5. Your Mr.
N.M. Azharpuria.
N.M. Mother Bhuya appears for the writ petitioner. List next week.
Highly obliged, Lordship.
Item 7.
My lord, it is a staff selection commission matter, my lord. Earlier, my lord, in the affidavit, we could not submit the matter for delay in filing this application. And thereafter, we filed the additional affidavit. And we have stated all the medical reports and everything, my lord. Due to this medical ground, my lord, we were prevented in approaching this honorable court at the earlier stage, my lord. So this additional affidavit contains the various medical reports and the discharge certificates and all these things. Not only the petitioner, his parents and wife, everybody were suffering, my lord.
From?
Lordship, it is 2018 recruitment policy. All the vacancies are filled up, Lordship. There is no more vacancy. This is the similar order path.
Are you challenging this election?
Yes.
You have to array the selected candidates, at least one of them.
I don't, one judgment of Supreme Court also is there. If it is not covered in the, it's reserved candidate, then it can be taken in the unreserved also.
But if he's suffering from serious ailments, he'll otherwise not be suited for defense service.
Any other, my lord.
This is for the constable.
This is for constable.
Yes.
Central Armed Police Force.
Yes.
You have to have a higher degree of physical fitness.
No, that, my lord, the petitioner, his parents were suffering.
No, petitioner also.
Petitioner was suffering from some cervical pain and all this thing. That was recovered, my lord.
You are challenging selection of 2018.
Yes. A list was published in 2021.
You are coming before the court in 25.
Yes, in 24, my lord, this court has allowed this application, my lord. We have annexed that order. And one Supreme Court judgment is also there, my lord. In the similar situation.
Right, there are counsel for parties, issue notice, within 4 weeks. Mr. S.S. Royal and CDC appears and represents all the respondents.
Lord.
As such notices are raised, extra copies will be furnished within a period of 1 week from today. The question of maintainability of the writ petition on account of delay and latches is kept open to be decided at the stage of admission.
Same lordship, 2018.
Same.
Lordship.
Lordship, here in this case, the petitioner scored lesser marks than the last selected candidate. But our case in this here is that the department, the SSC did not prepare the select list on the basis of the marks secured by the reserve candidate, while they were not taking the benefit of any relaxation. So had the SSC prepare the select list, keeping those persons as unreserved candidates, then the marks of the OBC would have come down. So in that event, we would have been given the, we would have been selected. Therefore, my guess is that the petitioner
We
maybe.
issue notice today.
Yes, no.
Right, council for party, we issue notice within about 4 weeks. Mr. S.S. Roy, done at CTC, he hasn't represents before. For all the respondents, therefore notices away, the extra copies we furnished within a period of 1 week. Since the petitioner has a say, the selection and recruitment pursuant to advertisement, selection and recruitment in CAPF, Central Armed Police Forces, pursuant to advertisement dated 21/7/2018. The question of maintainability of the writ petition, account of delay and latches, is left open to be decided in stage of admission.
Maintainability.
Maintainability, yes.
Nine.
Yes.
Thank you, Your Lordship. So at this stage, notice may be issued.
Tell us your case
Yes,
first.
yes, Lord. Well, matter pertains to depriving the rights of the petitioner for not appointing him with seniority. So now what happened? Lord, the petitioner had appeared in the departmental examination that was conducted in the year 2010. Now, by the strength of an order passed by this honorable court, where he was allowed to sit in the examination. Now, subsequent to that, my lord, 2011, the results were declared, where the result of the petitioner was withheld. But surprisingly, my lord, in 2013, another departmental examination was conducted, where his name was appeared, although he appeared back in 2010. Now, that departmental examination of 2013, my lord, the results were also declared. My name was not there in the list. Now, representation after representation, my lord, to declare my result and to promote me to the post of SI, but nothing was answered back. Now, my lord, only in 2015, my lord, my results were declared. And then I was directed to attend this pre-promotional cadre course that was held in the year February 2016. And after a lapse of good 6-7 months, he was appointed for the post of SI, Annam branch. Now the grievance is, my lord, those candidates who was sitting, who appeared with me in 2010 and those who appeared in 2013 were then promoted to the post of inspector rank.
Yes,
That's right.
Yes, but I will obtain instruction. Well, me have appear in the examination, departmental
Issue
examination.
notice today heard, learned council for parties is. Issue notice, Mr. P.C. Satia, learned state council represents all the respondents. All but the respondents, therefore notices of extra copies we furnished within a period of 1 week from the list again after the written condition.
Extra copy the extra copy. Right.
Yes.
Let me know. My lord, here two petitioners before your lordship. They were appointed, my lord, as casual worker, respectively, my lord, in the year 1995 and 2003, my lord. And they approached before this honorable court, my lord, as per, my lord, by page 10, my lord, page 41 and extra 10, my lord. And this honorable court, my lord, directed page 42 dated 10/4/2024 to my lord, consider my lord, their salary, my lord. As per the my lord judgment and order passed by this honorable court in the my lord, case of Upen Das, my lord. And accordingly, my lord.
Let's get your instructions here.
No, she noticed me.
Notice we are not issuing. You get instructions whether their
But
cases are considered or not.
yes, my lord, order is passed, my lord, but it is, my lord, said that lordship kindly will look, I am challenging this order, page 68, my lord. Here, my lord, the my lord commissioner said, my lord, page 69, my lord.
68 is passed in
My lord,
in your case.
in your case, my lord, in pursuance to that judgment, my lord, the commissioner passed this impugn order, which is under challenge before your lordship. Here, my lord, relevant portion, page 69. Here, my lord, from the bottom, my lord, third paragraph,
Your case has been
government.
rejected.
Yes, my lord.
Case has been rejected.
Rejected, my lord. It is said that, my lord, government finance, my lord, issued one letter
Petitioner,
to the
should
department, my lord, Panchayat department, not to.
returnable 4 weeks. Mr. A.K. Ghosh. Learned Council represents respondent number 3, 4, 5, 6, 7, 7. Yeah, 1 also. They actually have a respondent number 2. Who's for secretary?
Lordship for the secretary also.
Since the Learned Council represents respondents 1 to 7. Notice is waived, extra copies will be furnished to one week from today. Steps on respondent 8 and 9 by registered post within 1 week. Matter be received after the return of it.
Keep long.
11.
Please, your lordship. Lordship, I pray this matter be taken up after some time. D. Gogo is the engaged counsel. D. Gogo is the engaged counsel, your lordship. He's on legs in port number 1. Just pray this be taken after some time.
At the end of the list, motion list.
Lordship.
Yes.
Well,
May Lordship, petitioner is a constable lordship in CRPF lordship. Lordship, he joined in 2014 lordship. Lordship, after that lordship, he fell ill lordship in mental condition lordship, and he has been discharged lordship. In lordship, impugn order is 26 lordship.
Did you file an appeal?
Lordship.
You filed an appeal?
Lordship.
What happened?
Lordship, in page number 29 lordship.
What happened after that?
This is not an appeal.
Any orders passed in the appeal?
No lordship.
No orders.
No lordship.
No, so far as page 29 is concerned, my lord, this is not an appeal, my lord. This is simply a representation made to the department.
Treat it to be an appeal. It is a constable.
There is a specific provision in the Act, CRPC.
So who will educate him? You have thrown him out of the service.
My lord, actually, we have not thrown him out of the service.
Whatever
He has resigned from the service, my
all
lord.
right, whatever he's done,
Yes, my
he says that he's been thrown out
Yes.
forcefully. Somebody will have to tell him that this is how you have to prepare an appeal before the
My lord,
authority.
let the notice be issued at this time. We will accordingly file our reply, my lord.
So we wanted you to get instructions first to find out what is the status of this application or representation or appeal.
Deeply obliged, my lord.
You find out.
I shall try to obtain. Deeply obliged, my lord.
Third Learned Council for the petitioner claims that he was forced to resign from the employment of CRPF in which he was appointed. So, being agreed, he has filed a representation or a representation which he claims is an appeal before the higher authorities. The same has not been taken up for disposal by the competent authorities. So he submits that his discharge or resignation from the forces is completely illegal and was done for reasons not bona fide. Mr. Deka, B. Deka, Leonard CGC, will obtain instructions with regard to any orders that may have been passed in the appeal, in the representations stated to have been preferred by the petitioner. Stop. Petitioner was employed as a constable / cobbler.
Cobbler. May I draw Lordship attention, Lordship, page, office memorandum, Lordship, in page
Wait,
number.
let him get instructions.
Sorry.
Let me get.
Sorry.
The learned CGC will obtain instructions. At this stage, no notice is issued. However, sufficient extra copies we furnished within, how many days will you take to serving copies? 2 days?
2 days.
Within 2 working days. Matter be listed again on 5th of December.
Deeply obliged. my
Deeply
lord.
Link to obtain instructions.
I think certain.
This case, my lord, petitioner was retired from service on 21/7/24. Prior to his retirement, also, my lord, he filed the petition before this honorable court, my lord. And honorable court passed order, my lord, annexation 9, page 31. By, is a grade 4 master employee, my lord, daily basis, my lord, he work, my lord, and work more than, my lord, 30 years. Earlier order, my lord, page 31 onwards, my lord. By following the, my lord, the honorable division bench order opened as, my lord, the direction was given page 33, my lord, but they had not complied, my lord. Petitioner is not receiving anything, my lord. Otherwise, his last salary drawn certificate I have next year, last page, 16,380 rupees.
No, this judgment is page 35.
Lordship.
Which judgment you are referring to?
Oh, yes, my lord. Earlier case, my lord, this honorable court, my lord, pass order, my lord, page starts from 31, annexation 9.
What
And-
was the direction?
Direction, my lord, page 33, my lord.
33.
Yes, my lord. By following the honorable division bench order,
Retired benefit.
yes, my lord.
But Pendas,
Already stayed on the honorable apex court.
huh?
Honorable apex court, this order has been already stayed.
Which order?
This one, honorable division bench order. Recently, I have.
Where is that? Let us see.
And this,
Yes, that order has been state lordship. A copy of that order may be provided to us, lordship, because
no, no, yesterday I have heard.
state lordship heard.
Mm.
Lordship, a
From
copy
You
may be.
get us a copy.
Yes, ma'am.
The order has been.
But if that judgment is stayed, then why are you relying on this order?
No, no, earlier, I'm, because I'm placing the, because I have annexed this order, my lord, because, my lord, earlier also he filed this case. All whole track I have to place before the honorable court. And
Now, what do you want? What is your prayer now?
my prayer is that, my lord, I want to get, my lord, benefit after retirement, my lord.
You're
Retirement
right.
benefit and pensionary benefit.
You are what? Your
Lordship, Pendas is not pension, lordship. It is a minimum of the pay scale.
minimum of the wages.
No, that was followed in this. I prayed for, my lord, dear India earlier petition for regulation of our service, my lord.
That was rejected.
Yes, my lord, but that benefit has given, my lord, in view of the honorable division bench order, my lord. And now, my lord, your lordship,
Benefit of minimum of the pay scale has been given, lordship. That is Upendas. There is no pension involved in it, lordship.
now, my lord, my grievance is that, my lord, as it is fully not complied on. So, my lord, as, and also recent judgment, my lord, that is, my lord,
No.
Haram Singh judgment.
What is not fully complied? The directions of Upendas.
Yes, my lord.
But you say Upendas is stayed now.
Now stayed, my lord.
Then-
Now stayed.
Then how
So,
can
my
we
lord,
issue
my
orders?
prayer is at this stage, my lord, my prayer is to, in view of the honorable apex court order, my lord, Haram Singh petitioner case is covered, my lord.
That we'll have to examine.
Yes,
it.
my lord.
You can't. You have to first give us a copy of that order of the apex
Yes,
court.
my lord. I'll collect, my lord, next date.
Yes, Mr. Choliha?
Lordship, yes, at this stage, Lordship, notice may go because Lordship, here the prayer minimum of the pay scale as per the record, my learned friend is submitting, he is getting paid 16,000 something, that is the minimum. That's what Upendas he is receiving, Lordship. Now, regarding regularization and pension, Lordship, that is nowhere mentioned in Upendas, Lordship. So that is a different, so notice may go at this stage.
You are referring to which judgment? Dharam Singh?
Yes, my lord.
Where is it?
I have annexed here, my lord. Pay starts from that is
Page 47.
yes, my lord.
The entire, this writ petition is filed with the petitioner. Claiming that he is for rendering complete service to the PWD department. He PWD, na?
PWD before 1493.
Superannuated, but his consideration for payment of pension has not been granted. Stop earlier, he had approached his court, which the writ petition came to be closed with a direction by the court, placing reliance on the judgment of the division bench of this court rendered in Upendas, reported in so and so. Stop. The petitioner now is before the court, placing reliance on the judgment of the apex court, recent judgment of the apex court rendered in Dharam Singh, reported in so and so. We submit that the petitioner is entitled for grant of pension for the continued service that he had rendered. Stop. Considering the sufficient bail, let notice issue, return and move forward. Mr. Choliha represents all.
No, Lordship, I am appearing for finance, Lordship.
Mr. Choliha is for respondent number 3. MS
And they.
and
We
they
have
for
Pardhar.
respondent number 1, 2, 4 and 5. Since the respondents are represented, notices are waived, extra copies be furnished within a period of 1 week.
Lordship, here finance department may also be made as a party, Lordship, only treasury officer, because at the end of the day, Lordship, concurrence will be required from the finance. So if my learned friend can make the necessary changes, Lordship, because only the treasury officer has been made a party.
It is for him to decide.
Yes, Lordship, and this.
Yes.
Oh, let's
14.
Yes.
The petitioner is the BSF constable, Lordship, general duty, and petitioner before your Lordship is against the removal order. It is page 35, Lordship.
Appeal filed? Appeal?
No, Lordship, not filed.
Then why have you not filed appeal? They are there. Statutory provision for filing of appeal is there. Under the rules.
Rules, Lordship. Lordship, it is the summary proceeding, Lordship. He was removed under Rule 22, Sub-Rule 2, Lordship. Rule 22, Lordship. Dismissal or removal of the persons other than the officer. Rule, the BSF Rule 1969, Lords.
Yes.
22, Lordship. 22, it is Sub-Rule 2, Lordship. When after considering the reports on the misconduct of the person concerned, the competent authority is satisfied that the trial of such a person is inexpeditious or impracticable, but each of the opinion that his future retention in the service is
desirable, it shall so inform him together with all reports adverse to him, and he shall be called upon to submit in writing his explanation and defense, Lordship. Here, my grievances is that, Lordship, the report was not served to me. And here, Lordship, regarding the provisions of appeal, Lordship, section 117 of the Act, Lordship, it is against the findings of the Security Force Court. It is not here. I am not proceed under the court, Lordship. Only on the basis of the report, I was removed, Lordship.
Yes, madam.
Yes, Lordship, he has not make any appeal.
Under what provision? Appeal under which section?
uh, So cause notice also issued to him, Lordship.
Yes, Lordship.
Yes,
It is section rule 22 sub rule 2 is there before after issuing the so cause, Lordship. Along with the so cause, the reports should be furnished to the petitioner, Lordship. Here in this case, in my case, Lordship, the report was not furnished. That is my grievances, Lordship.
You are appointed as what?
Lordship, Constable General Duty. BSF Constable General Duty, Lordship.
At this stage, Lordship, notice have to, notice may be issued, Lordship.
I heard Mr. Chikwi responding as the counsel for the petitioner. The petitioner was appointed as Constable General Duty in 154 Battalion of the BSF. Pursuant to a complaint lodged by one person, petitioner was proceeded against under Rule 22 within bracket 2 of the BSF Rules 1969. Although a show cause notice was issued, however, by way of a summary proceedings, the petitioner was dismissed from service. Stop being aggrieved. Petitioner is before this court. Learned CGC MS Borua appears and respondents represents all the respondents. Therefore, notices are waived. Extra copies will be furnished within a period of 1 week from today. The respondents will complete their instructions and file necessary affidavits in the meantime. This is not a bench 2 matter.
Bench 3, my lord.
Then why mention was made that it is a bench 2 matter?
Maybe my mistake.
What are your challenges?
My lord,
here?
we have challenged the executive order annexure C at page
Why have you
53.
challenged?
Challenge, your lordship, may I read the relevant portion, my lord? The portion which we have challenged. That is page 53, column B, Roman 2, my lord. Applications of cases pending before DLC or SLCs wherein OM number so-and-so dated 18/9/2024 has not been put to challenge before Honorable High Court as on 3/4/2025, but after 3/4/25 shall be dealt with only in terms of office memorandum dated 18/9/2024 and shall be disposed of and intimated to the applicants by the respective DLC SLCs as the cases may be. The order dated 3/4/2025 passed in so and so shall not apply as precedent for cases that are filed on or after 4/4/2025 challenging the OM dated 18/9/2024. But after, my lord, this common order dated 3/4/2024, there is another order passed by the
coordinate bench of this honorable court, which I have my annexed, my lord. That is very much in force. That cannot be, my lord. Your lordship may kindly see that cannot be discarded by the respondent authorities. I have annexed as annexure A2, page 27, relevant portion, my lord. 26, 27. This was passed on, my lord, 4/6/2025. Page 26. The grievance of the petitioner pertains to rejection of his case for consideration for appointment on compassionate ground. Though here the details of the case is given, then at the bottom, by referring to the recent judgment of a coordinate bench rendered at 3/4/2025 in WPC
But
3/4.
why we challenge the executive order? That is not.
Yes, my lord.
Not clearly mentioned.
Because this.
Where his case is pending, lordship, who is
My
the
lord,
DLC or
I will
SLC
just
rejected,
complete my
lordship?
submission, I have stated, my lord. But in this
have
order
you
of the
challenged-
coordinate bench, my lord.
Have you challenged the notification also?
Yes, my lord.
In
We have
this-
challenged this executive order which says that they will only my lord, the SOP is applicable only in case of the cases who have challenged the office memorandum prior to 3/4/2025, my lord. But after that also, my lord, there are series of cases, and one case I have annexed, my lord. This is, my lord, the coordinate benches order, which has clarified the, my lord, para 9 and 10 of the earlier order, page 27, my lord.
Yes.
Page 27. After, at the bottom 26, I am reading, after going through the judgment and order dated 3/4/25, I find that although the learned single judge has clarified that the observations made therein would not lay down a binding precedent, yet there are certain directions and observations which in the opinion of this court would have a relevant bearing in the outcome of the present petition. The judgment and order dated 3/4/25, the learned single judge has made the following observations, that is para 9 and 10, my lord. These were quoted, my lord. And after that, there is the observation. It is made clear that in view of the consent of the my lord, that is not page 28, having regard to the peculiar facts and circumstances of the case, for the ends of justice, I am of the view that the petitioner's case deserves to be considered in the light of the above mentioned observation. As such, this petition is being disposed of at the stage of motion hearing by providing the petitioner's case be considered by the SLC in the light of observations made in paragraph 9 and 10 of the judgment dated 3/4/2025. So here the petitioner challenged the OM after 3/4/25, my lord, and this was considered by the honorable court, my lord. And after this, my lord, the petitioner's cases are also 6 numbers of petitioners, my lord. Here they have also challenged, and they in their cases also orders were passed. I have annexed the orders B series, my lord. So if only the executive, as per the executive order, my lord, if the SOP is only in respect of the petitioners who had challenged the OM, my lord.
Council for proposition.
It's approved.
It appears for all.
All the respondents.
All the respondents, they will notices the way. Extra copies will be furnished within a period of 1 week from today. Respondents may complete instructions and find their affidavits.
Obliged.
Listed.
Obliged.
Yes.
This again matter pertaining to old pension scheme. Lordship had the other day also admitted one matter. Batch of writ petitions are pending, my lord. Lordship would look at page 40, page 189, annex of 14.
Yes, some of the petitioners were.
They were left out. Initially, my lord, they were screened, but then they were then left out
Page
of
number?
the opinion. My lord, last page, Lordship would look page 196. This is in WPC.
Similar matter.
542 of 2024.
Similar matter.
Similar matters, my lord.
All right.
Batch of writ petitions have been.
Council for parties issue notice. It was 196 or 3,000. MS Eligible one. He is and represents respondents. All the respondents.
All the respondents.
B shall be, sorry. For all the respondents. Since the respondents are represented, notices of waived, extra copy to be furnished within a period of 1 week from the.
17.
May I please, your lordship?
Yes.
My lord, petitioner is a constable, my lord. A departmental proceeding was initiated against him, my lord, and he was awarded the penalty of stoppage of 5 annual increments, my lord.
Appeal not filed.
Appeal filed, appeal was dismissed, my lord. In the meantime, my lord, criminal case was disposed of and he was acquitted of the charges, my lord. Their petitioner filed a review petition to consider his case, my lord, in view of the judgment and order.
That was rejected.
That was rejected, my lord.
Heard council for parties issue rule. The matter, the petition is before the court challenging the order of the disciplinary authority imposing punishment or stoppage of
5 annual increments, my lord.
5 annual increments, as also the order passed by the appellate authority and the authority before whom a review petition was filed, which came to be dismissed. It is submitted that on the same charges, criminal petition which was filed before the competent court of criminal jurisdiction, the criminal court had acquitted the writ petitioner. Stop. Therefore, the imposition of punishment by the disciplinary authority on the same charges is assailed before this court. Since Mr. Chakraborty appears in
All the respondents.
Representative of the respondents. Notice on the respondents are waived. However, extra copies be furnished within a period of 1 week from the date. List is matter again after 4 weeks.
Deeply obliged.
18.
Yes, Mr. Das.
This is only a noticing though, because I have been asked for a compulsory retirement of this service. Because my only point here is that my appointing disciplinary authority, C becomes an inquiry officer. C becomes an inquiry officer. Now C, my lord, has removed me from the service. Same officer. That is a point to be decided later on, my lord. They let them give a reply whether it is correct or not. Because apparently only.
Why don't you take it up in appeal?
My lord, sorry. The governor, there's a orders of the governor. I have to go appeal and before the governor. That's the only difficulty. That's I asked first. Why not an appeal? The only point is that, my lord. And second point is that when a regular inquiry, my lord, was conducted, when the regular inquiry was conducted, they relied on the preliminary inquiry. Whether that can be done without giving a notice. That's the second point. So these are 2 points to be decided, my lord. In short, let a notice go, my lord, them give a reply. Because if I would not have been compulsory retired, then my services would have been up to 2026, 2026. So that's why I'm praying that if they can come up, at least 1 month time they require, I think, 4 weeks. They should give a reply to that, my lord.
You heard Mr. D. Das, senior counsel assisted by Mr.
K. Mohammed.
K. Mohammed. The petitioner is before this court putting a challenge to the order of punishment of compulsory retirement posed by the disciplinary authority on the basis of an inquiry purportedly conducted by the said disciplinary authority itself. That apart, while conducting the disciplinary authority, while conducting the inquiry, the disciplinary authority had relied on a preliminary report in which the writ petitioner was not given an opportunity to participate. You were not
Yes,
given
yes, no, nothing, my lord. Expertise also.
So under such circumstances, the imposition of punishment of compulsory retirement is put to challenge in the present declaration. There are Mr. T.C. Sutia, learned additional senior government advocate.
All the respondents.
Appears for all the respondents, therefore notices await, extra copies will furnish. Let the matter be listed again after 3 weeks.
Yes, right.
Respondents may complete their instructions and find necessary affidavit. The records relating to the departmental proceedings may also be kept ready for perusal of the court if they need.
My lord, I'm different. Can a date be fixed if it's not inconvenient?
5th December?
6.
Sorry. 8th of December.
8th of December is fine. I'm deeply obliged.
Item 90.
And Mr. Das, I think we have given 3 weeks, so it has to go later.
Let's see.
15 December.
15th. Right, 15th.
15 December.
15th.
15 December.
15th.
Please, your lordship.
Yes.
Lordship, it's a family pension. Can we see the lordship, annexure 1? It's covered by and the Fazil Rafi, Syed Fazil Rafi's judgment, lordship. It's covered by Syed Fazil Rafi's judgment, lordship.
Covered by?
Syed Fazil Rafi's judgment, lordship. Annexure 1.
Yes, Mr. Ghosh.
Lordship, notice me go, we'll have to see if.
What notice you examine and tell us whether it is covered? Why notice is required? You get your instructions by Monday and tell us.
So Monday is to sometime we will get.
The claim of the writ petitioner before the court is for grant of pensionary benefits for the services rendered as what?
Tax
Claim
collector.
of-
Tax collector.
Claim of the petitioner is pensionary benefits over this late husband for the services rendered as
Tax collector, lordship.
tax collector. Under which panchayat?
Kamrup Jila Parishad.
Kamrup Jila Parishad. Stop. Services of the petitioner's late husband was provincialized on 1/10/1991 and he died in harness on 2001/2002 while rendering service as tax collector. The counsel for the petitioner has pressed into service the judgment of this division bench judgment of this court rendered in Syed Muhammad Fazle Rabbi, reported in so and so. It is submitted that the facts and circumstances of this case is fairly covered by the judgment rendered in Fazle Rabbi Sutra. There are Mr. Ghosh, learned counsel, representing the respondents, is permitted 2 weeks' time to complete his instructions and apprise the court on this aspect. Although notices are not issued, extra copies be furnished within 2 working days. Matter be listed again on 5th of December. MSS Borua for
2 and 5.
2 and 5.
Item 20.
May I please? My lord, the petitioners, my lord, presently working as my lord homeguards in Srinagar district, my lord. My lord, initially, my lord, they were appointed in 2008, my lord. Thereafter, my lord, with break, my lord, after 6 months, after 1 year, my lord, they give a break and then again they deploy, my lord. And my lord, presently, my lord, they have been appointed, my lord, again on my lord, 1/8/2025, my lord. And my lord, their term is to my lord, and now my lord, they are my lord trying to my lord oust us my lord, from the service. That is the apprehension, my lord.
No, you were given, you are called into service for 3 months or so. How many?
My lord, as per my lord, in earlier case, my lord, they have filed a affidavit that only these persons are deployed only for 6 months. But provision says if there is requirement, government can extend their.
Requirement is there, but has any requirement been expressed?
My lord, in my place, my lord, they are trying to, my lord, deport some other persons. That means, my lord, there is some requirements, my lord.
All right, heard learned council for the petitioners issue notice return 4 weeks. MSS Borua, learned council for the state. Appears and represents all the respondents. Therefore, notices are waived, extra copies be furnished within a period of 1 week from the date. Based after returnable date.
Then meantime, my lord, some protection will give.
What protection?
My lord, some similar persons, my lord, approached this honorable court, my lord, but annexure 10, your lordship kindly see.
Annexure 10.
My lord, the relevant portion, your lordship will find at page 44, para 8, your lordship has, my lord, given some protection.
Para 8.
My lord.
Then,
Status quo, my lord, may kindly maintain. A similar seated persons, my lord, and the case will be taken to, my lord.
It is submitted that the apprehension expressed by the petitioner is for release of the petitioner from service to be replaced by some others persons. Under such circumstances, status quo as on date be granted.
in this matter,
Regarding
petitioner sub,
termination and release. Till the next date fixed, let this matter be listed again along with
1684 up to-
1684 23 on 12th of December. Respondents will complete their instructions and file necessary affidavit.
officers.
21.
May I please ask? In this case, my lord, though the petitioners were got marks, my lord, but subsequently, my lord, result was up to date. Only official website without cut-off marks, my lord. Without cut-off marks, my lord. And petitioners are scored mark in 77.3, so my lord, in the case, my lord. And my lord, in this case, my lord, when the petitioner check result, my lord, only can know the petitioner's result, my lord, without knowing the others, my lord. With the information, my lord, some less mark candidate, my lord, they are selected, my lord.
So, my lord, I will operate instruction petitioners only grievances that, my lord, selected candidate got more marks than them or not. I will obtain instruction.
Let him obtain instructions.
Yeah.
Counsel for the respondent will, Mr. T.C. Sutia will obtain instructions as to whether whether any candidate had secured more marks than the present writ petitioners. And or whether any person with lesser marks have been included in the select list. Let these instructions be placed before the court on when?
2 weeks, my lord.
8th of December.
8th of December. It will provide extra copies, my lord.
Extra copies be furnished. Although notices are not issued, extra copies be furnished within a period of 2 working days.
Yes.
22.
Yes, Mr.
May I please, Your Lordship? Your Lordship, in this matter, I have challenged the revised wage fair policy, Your Lordship, whereby this clause 12 is there, Your Lordship, turn to page 55. Clause 12, page 55. That contractor shall not engage, employ or deploy any workman when the contract execution who has raised any industrial or river, either personally or through a union, claiming regular employment or higher wages in ONGC. However, ONGC shall provide details of work exemption. So your Lordship is taken up because I have filed a case for all the 4 petitions have filed a case for regulations that is pending in this honorable court, Your Lordship. Now, out of the 4, 2 have been discontinued. If Your Lordship will see, because litigation, they have filed cases against the from 1/9/2025, your lordship. That cannot be done because they cannot override the judicial process, your lordship. If your lordship see, turn to their letters, your lordship see.
No, all these petitioners are before the court in some other writ petition.
Request to us once for regulation and for higher, that is there. That is pending in this honor.
Now, what are you praying here?
Praying here, because out of the 4, 2 have been discontinued because they are pursuing the litigation here. 2 are still in our service. 2 have been discontinued. If your lordship will see this page, your lordship, here it starts. If your lordship turn to page 63, your lordship, this one contractor has said, your lordship will see.
So, who are the 2 petitioners?
Petitioners are 2 and 3 have been discontinued, your lordship, out of 4.
Are the provisions of ID Act not applicable?
No, ID here is a question of the ID Act. Here question I am challenging the policy itself.
Policy.
Yes.
Now, why 1 and 4 are also before the court?
Because they may be apprehended. They are still in service. They may be also affected by this thing.
Oh.
That's the reason, your
Our clear counsel for the party, writ petitioner. Petitioners before the court are putting a challenge to which order?
A fairest policy, your lordship, that is an annexure, your lordship, that is annexure. Yes. Annexure P1, your lordship, annexure P1.
Page number?
Page 53 to 55 and clause 12 in particular, your lordship.
No, you said they have been disengaged by which order?
But disengaged here, this is there. This your lordship see. There is under the instruction of this. If I just take your lordship to this, if you don't mind, your lordship. This is they have the ONG has issued a email, your lordship. That is page 50, 53, 58, your lordship. This is a typed copy or original copy is down below, your lordship. My lord, page 58, your lordship. As per clause 12 of the revised FAIRS so and so, you are directed not to engage, employ or deploy workmen or contractor who has raised any industrial labor either person or through union claiming regular or higher wages in ONG. However, ONG shall provide. So this is the thing, your lordship. Then based on this, the contractor, the so-called contractor has disengaged me. Although he has been engaged only in after this FAIRS policy, and we have been working since 2007 and 2010, your lordship, to our continuing service. They have been disengaged because they are claiming regulation service and higher pay scale. So if your lordship see the next page 63, letter of disengagement, your lordship. This is a contract. I am regret to inform you that I could not engage in the work of hiring of job contract for Assam as per direction from my principal employer ONGCL in purview of the clause number 12 revised FAIRS policy number so and so so and so. That is, if you lordship take page 64 next. My name is at 28 and 35 serial number. 64, page 64.
Your name is it?
Page serial number 28 and 35, your lordship.
28.
And 35. You have also say litigation, he said litigation written here also.
And 35.
Yes, sir. One is petition number 2, one is petition number 3. 20 is 2.
And where are the other 2?
Other two is still continuing. They are continuing. But they also run the risk of the same thing because clause 12 and they'll tomorrow or after they will be terminated also there.
Our counsel for the parties, the petitioners before the court have challenged the revised fair wage policy adopted by the ONGC.
2025, your lordship. 2025.
Dated 28/7/2025. Stop. This is the subject matter of what are the other writ petition numbers?
It is given 163.
This policy challenge in those writ petitions.
No policy. This is from that was 2022. I filed the yes.
Okay. Right, and now when you write has challenged these policies by which the certain non-negotiable payments and facilities to be provided by contractors have been laid down in respect of the persons working under the contract laborers, working as contract laborers.
Actually, they are not working. Our case, we are as contingent workmen, not contract laborers.
This is our case, because one appointment letter is also been placed here, Lordship, annexure P2.
The-
That's
the working is contingent.
contingent workman.
Contingent workman.
Yeah, otherwise there will get confusion, Your Lordship.
The writ petitioner had already approached this court by filing WPC 1638 of 2022 for claiming regularization in the services in the posts held by them since the year 2006 till date. Stop. Since the petitioners had challenged this policy, who of the writ petitioners being, who were terminated?
Petition number 2 and 3
Petitioner number 2 and 3
have been disengaged.
have been disengaged by the ONGC
This is the letter, Your
on the
Lordship,
ground
annexure,
that they were engaged in litigation.
annexure P5 collectively, Your Lordship.
This a communication dated 1/9/2025 was issued, was submitted by these contract employer. He's what?
He has been engaged by the ONGC, Your Lordship.
For what?
For hiring service, it's for hiring of job contract unskilled labor service. It is written here. Page
Issued by the
63,
contractor.
page 63, Your Lordship.
By the communication dated 1/9/2025, whereby names of the writ petitioners 2 and 3 are reflected with serial number 28 and 35, with the endorsement within courts litigation against their names. Stop. It is submitted that it is because of the litigations filed by the petitioners that their names have been discontinued. Stop. Apprehending such action against the other persons, petitioners 1 and 4 have also joined together to file the present writ petition. At this stage, the court considers it appropriate to issue notice. Let notice issue returnable 4 weeks, returnable 6 weeks. Steps on the sole respondent by speed post. You want to take Dusty?
That is, take that. That's also.
Petitioners, speed post within 1 week from today. Service by way of Dusty is also permitted, provided the same is routed through the registry of the court. An affidavit of compliance shall also be
Your
filed.
Honor, note interim,
Steps by
interim player also.
Dusty is routed. Stop. What interim prayer?
Interim player, because because if the notice, clause 12 is not stayed, Your Honor, it will be for these people also, because of clause 12, they have been disengaged, Your Honor. But clause 12 is, if Your Lordship see, it's overreaching the power of the code, Your Honor.
Till the next returnable date. But 2 and 3 have already been disengaged.
Disengaged because of the clause 12, Your Honor. Yeah.
But against 2 and 3, there can be an interim order.
But 1 and 4 can be there, Your Honor. 1 and 4.
Right, till the next returnable date. The respondents will not alter the service conditions in respect of respondent petitioners 1 and 4 in terms of the 2025 policy. Let this matter be listed again on January 21.
Your Lordship, can it have it on 19th or so?
19 January. We can have it on, because we are giving you the 6 weeks time.
Yes, Your Lordship.
Will not be over before 19, before 21st.
Then Your Lordship, have it
28th.
20.
28.
No, it at 20, Your Lordship is giving 21. 21. Can it be 24, 25th? 25th holiday over there. Calendar is not there.
25th, 26th holiday.
Oh, Your Lordship, then Your Lordship, give me the one day then.
Huh?
One day that,
No
20
Monday. Then it goes to February 2nd.
no. So already the whole
No, we're giving you 21st, 28th,
25, 35, 28, yes, sir.
28th.
Yes, sir.
Oh, that's 28th. 28th of January,
Keep your-
2026.
And then 23.
এই ক্যালেন্ডার তাদের নাই না, জানুয়ারি ক্যালেন্ডার হবে। কি বলে দিন? Yes.
Made it in lawsuit. But the petitioner, people lawsuit was working as in charge Bambura of charge number 12 under Bagbor Revenue Circle. Malad. What happened, Malad, an advertisement was issued on 9/3/2022 for filling up the post on regular basis. Pursuant to the advertisement, the select list was published on 3/1/2023.
Now there is another review or something,
Yes, 162
review
Malad.
under 162D.
D.
162D,
Malad.
you file a review.
Malad, what happened, Malad?
Unless you say
this
there is
order
no
has been
authority.
passed. This order has been passed, Malad, without considering the fact that Malad, the respondent number 6 does not have the landed property in the under the charge.
Right, you re-agitated before the.
Oh, yes.
Malad, they are Malad contemplating to appoint the private respondent. Malad, I will file the appeal, Malad, within 2 days. Malad, in the meantime, Malad, I may be protected, Malad.
He has been already.
Yes,
But that is not a ground, 11/11/25.
Yes, Malad. Till that, Malad, he has not been appointed, Malad. I have the instruction, Malad.
He is the selected candidate.
He is the selected candidate, but
Ah.
Malad, he is not qualified. But under the Malad,
You are not selected.
I was the in charge, Malad. I'm not selected.
You are not selected.
I have secured Malad 24.3 and he has secured Malad 24.4.
Whatever you may have secured, he is selected. You are
Yes.
challenging his appointment.
Yes, Malad.
Now, you are the in charge government.
Malad.
You are still holding.
I'm
charge.
still holding Malad. Earlier, Malad, lawsuit protected me, Malad.
So we protected you once, doesn't mean you come back again for another protection.
Malad, that
You
by
should
the
have gone in.
impugn order, Malad, by the Malad appellate authority, he has Malad he did not consider the vital aspect that the respondent number 6 does not have the landed property under the charge. That
So
aspect-
therefore, go for review before the state government.
In the meantime, Malad, he may not be, Malad, I may be allowed to continue.
When can you file the?
Day after tomorrow, I'll file, Malad.
All right, heard counsel for parties, the petitioner before this court he is challenging the order passed in appeal dated 11/11/25.
Right here.
According to the writ petitioner, the private respondent number 6, who was the selected candidate for the which ground,
Charge number 12, Sukwarjar,
where does one find it?
but in the prayer also, Malad, I have mentioned,
Charge number 12,
my lord,
Bagbor Moza.
my lord. Sukwarjar.
Where have you stated it? Charge number 12, Bagbor Moza, under
Bagbor Revenue Circle.
Bagbor Revenue Circle. Did not have the required eligibility as per the advertisement dated. 3/9/25. Stop. Counsel for the petitioner therefore submits that he had earlier approached his court when he was relegated to file the statutory appeal, which he had filed. And the appellate authority, without taking into consideration the relevant issues, rejected the appeal filed by the petitioner.
In fact, Malad, in the appeal order, Malad, all has been considered. Even if what is the allegation about the respondent number 6, that has already been point by point considered.
What happened to the earlier writ petition?
Well, earlier petition was disposed of, my lord, by this honorable court, directing the appellate authority to decide the.
Where is that order?
Well, that order, lordship will find page 72, my lord.
Seventy-three.
Subsequently, the illegal last, where the appellate authority did not consider the issues raised. They agree the present petition is been filed. Stop para Mr. T.C. Sudhia as well as Mr. S. Dr. Council appearing with the respondents have pointed out that under executive instructions 162 hyphen capital D.
D.
D for Delhi.
Delhi.
There is a provision for a review. Which can be preferred against any orders filed by the appellate authority. Stop. The petitioner has not availed of that statutory remedy and has not explained as to why the remedy could not be availed of. But, considering the submissions made, this court and also taking into consideration the provisions available at executive instructions 162P. This court is of the view that the end of justice will be met if the petitioner is relegated to the statutory authority for filing a review under executive instructions 162D of the Some Land and Revenue Regulation 1886. Accordingly, the writ petitioner will now approach the authorities prescribed under Regulation 162D and file a review petition within 1 week.
Man.
Respondent number C is already released, my lord. Page 75. Respondent number petitioner has already been released.
No, thereafter many orders have been passed.
23
That release order was cancelled by themselves only.
Where is that?
Page 75.
Sahara Khatun Gaon Pradhan, Kiral Baghor Saikul, has been released from her duties as
Right,
Gaon Pradhan.
the appeal is filed within 1 week as directed, then the petitioner who claims that he is not, who is the in charge Gamuda and has not handed over charge till date. And if this position is found to be correct by the authorities, then the petitioner shall not be relieved of for a period of 1 week from today or till the appeal is filed before the review. Till the review is filed before the authorities as directed under Executive Instruction 162D. So,
He has not been released, my
the
lord.
interim order will continue till 3rd of December. Sorry. Till 26th of December.
Till final disposal of the review, ma'am.
26th of December. Any interim orders found necessary can also be issued by the authority hearing the review petition.
Review authority.
Yes.
Dispose of, my lord.
Would like to go to Hopta with I will sit the language. Yes.
For inspection, it was fixed. 36 for inspection, it was fixed.
For instruction.
36. Also, instruction related lots of finding.
Huh?
2 weeks time will be granted.
Mr. S. Nath for the petitioner, Mr. H. Chakraborty for the respondents. Stop Mr. Chakraborty, prays for further 2 weeks' time. Complete his instructions. Prayer mate is not objected to. Again after 2 weeks.
Maybe a date fixed.
8th of December.
Obliging.
Zero 37.
See, here the petition is a constable in SSV. In the year when he was posted at Howley, he was granted risk and hardship allowance for the period from 2019 to 2022. Lordship, now the department has passed an order for recovery of that.
We have passed some orders.
Yes, Lordship. I have some similarly
Yes,
stated, but can approach this normal code, page 86, Lord.
Page number
86.
56.
The order is start with page 91, Lord.
56.
No, 86, Lord. It start-
86.
86, 86. There are so many petitioners, orders start from page 91, Lord.
I heard learned counsel for the parties. Petitioners are challenging where is the communication for recovery?
Lordship, page, Lord. And Lord.
Yes, recovery of the risk and hardship allowance, which was earlier granted to the petitioners. Stop being agreed, the present writ petition has been filed. It is submitted that similar writ petitions have been filed by other similarly situated persons, which are pending before the court. And considering the submissions made, let notice issue returned in 4 weeks. Mr. S.S. Roy appears for all respondents.
All respondents.
Therefore, notice is waived, extra copies will be furnished within a period of 1 week from today. Let these matters be listed. 4 weeks, no, 6 weeks, be listed. Along with WPC 168 of 2025, another batch of writ petitions. And until further orders, there shall be no recovery of risk and hardship allowance from the writ petitions.
Much obliged.
Time being at 11.
Sorry, well, I was on legs in one. Look here, these are the petitioners belonging to 175 battalion, the CRPF. Now they have been transferred to other posts. While they were in service, they were granted a
Risk
allowance.
and hardship.
Yes, my lords. Now they are trying to
Passed similar order.
similar order. Right?
Same order, right? Council to parties. Council name will change. Mr. Doctor appears for all the respondents. These matters we listed along with the other writ petition before the till the next date fixed. Now, till the next date fixed, until further orders, there shall be no recovery of risk and hardship allowance.
Obliged.
List accordingly. A matter of providing.
Supplementary list for withdrawal, IP number 43.
In view of the submissions made by the learned counsel for the petitioner on instructions that the writ petitioner does not wish to press the writ petition any further. Accordingly, the writ petition stands dismissed as not pressed in three orders if any stands vacated. Pending IL are also dismissed.
Lordship, I pray
Yes.
for liberty, Lordship. I pray for liberty.
So why are you withdrawing it?
Actually,
Why are you not pressing it now?
Your Lordship, it was for regularization of contractual employment. And actually, we have been given some, like there is some talk perhaps there.
Also, why do you want liberty? For a fresh cause of action, you don't need liberty. For the same cause of action, you need liberty, but if you have some cause of action, why are you not pressing it?
That is the instruction I have received, and at this stage,
No liberty required.
obliged.
MSP Borua for
For 2 and 3.
2 and 3. And MSS Borua for state.
Okay.
Hmm.
Obliged, Your Lordship.
44.
44 is the same.
Same, that's it.
Same order.
Yes.
Same order. Interim orders, if any, stand vacated.
Obliged, Your Lordship.
Daily list for order 1325.
My lord, in this case, my lord, the first notice was not accepted, returned, my lord. Thereafter, second notice was issued, my lord. Yes, anything? Oh.
But we'll file affidavit, my lord, because the alleged contemner, he was not a party to the earlier proceedings.
No.
And now you represent the respondents.
Yes, my lord,
Right.
we'll file affidavit.
Name is S and N S Thakuria appears for the petitioner. Mr. H. Gupta, learned CDC, represents the respondents.
Sole.
How many respondents?
Only one, my lord, sole
Sole
respondent.
respondent. He submits on instructions that he would like to file an affidavit in the matter. Let this affidavit be filed within 2 weeks.
No.
Matter thereafter be listed after 2 weeks.
Obliged, my lord.
26.
The service about respondent number 1 and 3 are awaited, and however, respondent number 2 appeared last occasion on 29/5/2024, and they sought for 4 weeks
Are you
time to
taking
file.
fresh
reply.
steps or by Dusty? Fresh steps.
Fresh steps, my lord.
Counsel for the petitioner is permitted to take fresh steps on respondent number 1 and 3. As the office note dated 15/7/2025 reflects that the notices have returned unserved and
For respondent number 2, we'll have to
both
implement.
the respondents. Mr. A.K. Ghosh for respondent 2.
No, Lordship, I have filed Wakalatnama on behalf of 1. 2 wins,
For 1.
yes.
Who's for 2?
Lordship, for 2, we'll have to implement newly. The incumbent has been transferred.
The incumbent is transferred.
I mean,
but
the earlier-
his responsibility to answer as to why the order was not complied with.
We have the instruction.
Does not disappear because he's transferred. Are you are representing 2 also?
No, Lordship, on 1.
Well, last occasion, Mrs. U. Sharma appeared on 29/5/2024, sought for 4 weeks time to
Alright,
file
then-
reply.
Then you say that the counsel for petitioner is permitted to take fresh steps on respondent number 3 by registered at the correct address. Mr. A.K. Ghosh has entered appearance on behalf of respondent 1. And he prays for time to file his affidavit. Ms. U. Sharma had represented respondent 2, but is not available in court today. Respondents 1 and 2 are permitted to complete their instructions and file necessary affidavit. Accordingly.
Well,
27.
I'm already appear for respondent 1 and 3, my lord. When 2, I have instructed to appear. I'll file Okalama today itself. So some 3 weeks time may be granted to file it.
My lord, the
Yes.
services has already been completed, and as per Lozima Court order dated 11/6/2025.
He is appearing on behalf of all.
Yes, my lord. The petitioner, a date may be fixed, my lord, in the first month of
Counsel
December.
for petitioner so and so, Mr. S.K. Bedi. Then the counsel represents all the respondents.
All the respondents. I'm going to file
Wait
Okalama.
for further time to complete his instructions. List accordingly. Yes. Yes. After 2 weeks.
A date may be fixed.
After 2 weeks. Come after 2 weeks.
Second 28.
Okay, sir. The service is not complete, but the AD card is not. May I pray, my lord, that I may take Dusty, my lord. Dusty may be permitted.
Counsel for the petitioner submits that you'd like to take steps by Dusty. As the office note dated 13/10/2025 reflects that no AD card has been received. List again after 3 weeks. Stop. Mr. Gupta is permitted to take service by way of Dusty routed through the registry. On the sole respondent.
Sole respondent.
Affidavit of compliance we also file after service of Dusty.
Second 29.
May I please, Lordship, a repetition was filed for not giving me appointment though I am selected. Therefore, on 29/1/2025, the Honorable High Court passed an order, Lordship, page 20 of the I. Second paragraph. Taking note of the grievances of the petitioner could not have had granted time to the learned common advocate to obtain instruction in the matter. Today, when the matter is taken up, Mr. So-and-so produced written instruction according to which the petitioner has been selected and the process of issuance of appointment order is in his favor in advanced stage. If so, it is apparent that the grievance of petitioner has already been redressed. Therefore, Lordship, the petition was closed. In view of the above, by retaining a copy of the written instruction dated so and so, produced by the learned common advocate, this writ petition is closed. But till now, Lordship, appointment has not been given. So I am therefore.
How can you open it? You file a review if you want.
Yes, Lordship. Because it was not disposed of, it was closed, Lordship, therefore I.
Whatever it may be, how can it be reopened now? By way of an IA?
I thought about it, Lordship.
You take whatever appropriate steps are there. Whatever proceedings you want to file, you file, but by an IA to reopen, dispose of matter.
Yes. It will come under the sufficient clause, but there is no error apparent on.
No, we can't advise you what you should do, but apparently the writ petition was closed on the basis of the submissions made.
Yes.
And a copy of the instructions retained.
Yeah.
Then,
Lordship. Therefore, let me allow me to withdraw it with liberty to file appropriate proceeding.
right, counsel for petitioner seeks to withdraw this IA. Prayer made is allowed. IA dismissed on withdrawal.
Yes, Lordship will grant liberty for appropriate proceedings or review.
Liberty, however, is granted to the petitioner to approach the appropriate forum with appropriate proceedings. By way of appropriate proceedings.
Deeply.
I can 30.
Lordship, this is an application for amendment of regulation, my lord. Lordship may kindly refer to para 4 and 5, my lord. They have dismissed my appeal, my lord, after 7 years.
Any objections or amendment?
Well, we have already filed in the writ petition, my lord, affidavit. So again, we will have to file affidavit.
That is not a ground for objection.
That is true, my lord.
Only thing is that will it change the nature of the suit or the proceedings? He is already challenging the order of the disciplinary authority.
Disciplinary authority.
Now the order of the appellate authority is to be challenged. Will not change the nature. Heard learned counsel for the applicant, as also the counsel, state counsel representing the state, Mr. T.C. Sutia. Petitioner has filed an application seeking amendment of the writ petition being WPC number so and so, which has already been filed by the petitioner and is pending. Stop. The writ petition has challenged the order passed by the disciplinary authority against the petitioner / applicant. However, prior to filing the writ petition, the petitioner had also preferred an appeal, statutory appeal, as prescribed under the rules of Discipline and Appeal Rules 1964. Stop. This appeal at the time when the writ petition was filed was not disposed of. Stop. Subsequently, this appeal came to be disposed of by order dated 12/8/25.
Yes,
Whereby the appeal has been dismissed.
appeal has been dismissed.
Stop. Since the appeal has been dismissed, arising out of appeal preferred by the petitioner has been dismissed, putting a challenge to the order passed by the disciplinary authorities. And since the order passed by the disciplinary authority is also assailed in the writ petition, the petitioner, the applicant has filed his application seeking amendment of the writ petition to incorporate the necessary amendments for assailing the order passed by the appellate authority. Stop. It is para. Mr. T.C. Sutia, learned counsel for the respondent, submits that since the affidavit has already been filed by the state and the matter was at the state has been heard at the state, amendment should not be allowed. Considering the submissions made and also on perusal of the order passed by the appellate authority, this court is of the view that the petition essentially challenges the order passed by the disciplinary authority dated so and so, whereby punishment of what? Increment.
Punishment a minor penalty of withdrawal of one increment.
And withdrawal of one increment was imposed. Stop. Prior to filing the writ petition, the petitioner had also filed an appeal before the statutory authority prescribed under the rules 1964. Stop. The appellate authority did not dispose of the appeal at the time, at the relevant point in time, because of which petitioner had approached this court. Stop. However, during the pendency of the appeal, the writ petition, the appeal was disposed of by order dated so and so, confirming the order passed by the disciplinary authority. Stop. Under such circumstances, the present petitioner has filed an application for amendment of the writ petition to so that the order of the appellate authority is also can also be assailed. Stop. Under the principles of Order 6 CPC, the amendments are to be allowed, subject to the condition that it does not change the nature of the suit. Stop. In the present proceedings, the challenge is to the order passed by the disciplinary authority imposing punishment on the writ petitioner and which came to be upheld by the appellate authority. Stop. I mean, grant of amendment at this stage, according to the court, will not alter the structure or the nature of the writ petition. Stop. Rather, it will reduce the multiplicity of litigation, which the writ petitioner otherwise may be required to file before the court by a separate proceeding challenging the order passed in the appeal. So, under such circumstances, this highest stands allowed. Petitioner applicant is permitted to make necessary amendments as reflected in
Para 5.
para 5 of the IA. So, para 5 of the IA therefore reads as under para 5 A, B, C, D. These paragraphs will be incorporated in the after the paragraphs, in or after the paragraphs as indicated in para 5 of these IA. Stop. IA, para IA accordingly stands allowed, disposed of. The writ petition will petitioner, the applicant writ petitioner will file amended writ petition within 4 weeks from today. And the matter be placed before the court. Stop. The respondents are also permitted to file additional affidavits in opposition if they are so advised. Pursuant to the amended writ petition being filed and copies thereof being served as the respondent.
Right. 31.
Earlier incumbent has transferred lots of new incumbent has come, so.
Yes, I is filed for impeachment of the
Commissioner
respondent from the party, Sri Pawan Terang,
Lordship.
in place of, in addition to the respondent who's arraigned in contempt case number 231 of 2025. So it is submitted that the earlier incumbent, namely respondent, sole respondent in contempt case number so and so, has since demitted office, and therefore the present opposite party is required to be arraigned as the respondent. Prayer made is not objected to by the counsel representing respondent 1, the sole respondent in contempt case number so and so. Stop accordingly, I stands allowed. Sri Pawan Terang is permitted to be arraigned as respondent number 2 in contempt case number so and so by filing amended course title. So the writ petitioner, contempt petitioner will file amended course title within 2 weeks. So the registry, upon receipt of the amended course title, will thereafter list the contempt case number so and so. IA so and so stands disposed of.
Obliged.
Supplementary list for order item 38.
Well, in this case, I have received the instruction, I want to file an affidavit to bring the same on record,
Yes.
See, order dated 13/2020, not yet compliant, so
Let him file affidavit.
only fix the date.
NJ Gogoi, counsel appears for the petitioner. Mr. PK Bora, learned counsel, represents the respondent.
1. 2 weeks time.
He renews his prayer for filing affidavit within 2 weeks. Prayer made is allowed. Let the matter be listed again after 2 weeks, enabling the learned counsel for respondent 1 to file the necessary affidavit. So.
Can I fix the date, order is in the year 2023.
8th of December.
Obliged, man. Obliged.
39.
In this case, we have taken steps. You will kindly say, opposition dated 12/11/25. Notice has been served to my testimony number 2, report has been.
Office note dated 12/11/2025 reflects respondent 2 has been served. Stop. Registry will place the matter before the Lozima court for passing necessary orders on the service of the respondents. Let it be placed before the Lozima, they will examine and pass orders. Matter be listed after 1 week. 2 weeks. 2 weeks. Lozima will require some time to verify.
Item 40.
None appears for the petitioner of court. Matter stands passed over.
May it please the lordship. My lord, as per order dated 27/10/25, my lord, the standing council was directed to apprise this honorable court to release whether the pensionary benefits have been released or not. My information is that, my lord, till today, my lord, my clients has not received the pensionary benefits.
See, we have received instructions that GIS and the unutilized earned leave has been sanctioned. What should we believe this?
The question is whether you have released the benefits amounts due. Sanction is different. Why the amounts due have not been released?
I'll pray some time to.
How much time do you want? Why do you keep on praying for time? Direction was passed when?
She retired in 2020, my lord.
Order was passed on 24/4/24. Directing you to comply with 60 days. We are giving you 2 weeks further time. Either you comply or we are issuing contempt notice. You are not even posted with proper instructions. This is the sanction order.
Yes,
How much time will it require to prepare the papers and send it? Whose responsibility is it?
So it will come from the commissioner. It will come from the
So
commissioner.
let him go to jail
No, no.
while the amount is being released. Once
Yes.
it is released, he'll come out. Who is the person giving you instructions? Commissioner.
Lordship may grant me 2 weeks time. I'll make sure of the updated instructions.
Why do you require a reminder from the court? You are a counsel representing and you are supposed to apprise the court. They have sanctioned, is that the end of the matter? He is not received the amount in terms of the directions. You are entitled to file a review, go in appeal against the orders passed.
Lordship, the order has already been copy marked to the petitioner also.
Does it answer the query of the
No,
court?
That doesn't, but.
But
Lordship,
no,
Does it amount to compliance of this order?
Lordship may grant me 2 weeks. I'll obtain the instructions.
let him personally appear before this honorable court, my lord.
So what will happen?
My lord,
Rather we invoke their contempt jurisdiction and issue orders. The departments are not willing to comply with.
No, Lordship, that.
Either they are not willing to comply with or the council unfortunately is not able to convey the intention of the court in these orders. Have you got instructions? Who gave you these instructions?
So from the commissioner office.
When did you receive it?
For yesterday.
Yesterday. Has any consequential instructions been given? When is this amount likely to
No.
be transferred? Did you ask them? Did not. Why? Is that the order of the court? That the respondents will sanction the order and that is the direction of the court? No. Counsel for the respondent, Mr. Ghosh, has placed before the court an order dated 14/11/2025 sanctioning an order issued by Commissioner, Panchayat and Rural Development, sanctioning an amount of rupees 7,01,770. Stop. He has, however, no instructions when these amounts will be transferred to the account of the writ petitioner and the process involved there too. Stop. The council has prayed for 2 weeks further time to complete those instructions and apprise the court as to when the amounts directed to be released to the petitioner by order dated 24/4/2024 passed in WPC 6332 of 2022 shall be complied with. It is made clear that if specific instructions are not placed before the court, the court may proceed to invoke its jurisdiction under the Contempt of Courts Act and pass appropriate orders.
my lord, a date may be fixed, my lord.
List this matter again on 12th of December.
Well,
Daily list for article item 32.
Yes.
My lord, this is for appointment of the arbitrator. Here, my lord, the appointing authority failed to act as required under the arbitration clause. And lordship arbitration clause is at page 55.
Yes.
And lordship, as per the requirement of this clause 25, the petitioner also demanded for constitution of the DRC, but they failed to constitute the DRC within the stipulated period of 15 days. And so thereafter, the petitioner invoked the arbitration clause at page 120, my lord. But the respondent declined to appoint the arbitrator, and otherwise also they cannot appoint the arbitrator. The party to the contract, as per the settled law, your lordship cannot appoint the arbitrator.
Where is the clause 25?
Clause at page 55, my lord.
55.
55.
55.
It starts from page 55. Settlement of dispute and arbitration, clause 25.
So, is there a process of
DRC.
Dispute redressal
Committee.
forum.
Committee.
Yes, but they failed to act within the time provided, and law does not permit to give second chance to them.
So first, you filed an application before the engineer in charge.
Yes,
Where is that?
at page 102, my lord.
102. Then
Then, my lord,
what happened after that?
after that, it was received by the engineer in charge at page 108.
108.
Acknowledgement is there. Now time is given to 15 days.
When was it received?
He wanted, it was received on 30/11/2022 as acknowledged by them and in annexure 33, page 108.
Yes, 30/11, then 15 days,
Yes, 15 days.
which is 15.
Yes, 15 December. But on 9 December, next page, your lordship may see. They wanted to rewrite the arbitration clause. In other words, they wanted to change the DRC. And I am not bound by the change in the DRC and I am not bound to give the consent. In the meantime, 50 days expired. So they forfeited their right to ask for the DRC. Subsequently, what happened, that is not material, my lord, as per the settled law. So I have no alternative but to invoke the arbitration clause at page 120, my lord.
To which, any reply?
Page 120.
Then any reply?
Yes, reply is there. They declined to appoint the arbitrator on erroneous ground at page 127, my lord.
127.
NHR 43. This is about the final bill. Then next page, your lordship, is there about this.
Then
128. They inform about the condition to go for DRC, which they forfeited their right. So your application, last paragraph, your application for appointment of arbitrator is incomplete without attaching the decision of the DRC. So here also they forfeited their right to appoint the arbitrator.
yes, Mr.
Yes, Lordship.
Medi.
Yes, Lordship. Your Lordship, in this case, I have filed our affidavit in opposition, Your Lordship. Your Lordship, kindly the page 109, Your Lordship. 109 writ petition, Your Lordship. That this is the letter, Your Lordship, issued by Executive Engineer Project Division, CPW, Guwahati 21. That time, Your Lordship, we have wrote a letter to the petitioner for asking for consent, Your Lordship. Earlier, what happened, Your Lordship? There's a 3-member committee, chief engineer, and the 2 members. Earlier, both are from Guwahati region, Your Lordship. That time, a respondent has taken the decision that 1 member should be outside Guwahati, Your Lordship. So for that outside Guwahati, so for that region, Your Lordship, we have asked a letter to them to give a consent that 1 member should be outside, Your Lordship, Guwahati. So Lordship, kindly page, Your Lordship, 112, Your Lordship.
No, fact is that in your agreement as it stood on the day when
Yes,
the
Lordship.
disputes arose, there was a process of
Lordship.
DRC
Lordship.
that they have applied.
Yes,
Requested
yes,
you.
Lordship.
You did not proceed to refer it to
Lordship,
DRC. Rather, you wanted to amend the clause.
We have amended that clause. Thereafter, again, whenever they send their dissenting consent, Your Lordship, again, they reconstitute the member or committee, Your Lordship. Again, we have taken back the earlier member, Your Lordship. Then we have again sent them to, yes, in your
No,
opinion.
what happened after that?
After that, we are
What decision-
requesting them to send your place your grievances before the DRC. They even did not, Your Lordship.
No, but that has already been sent by your earlier letter.
No, Lordship, kindly 116, Your Lordship. This is the Lordship letter, Your Lordship. May I read, Your
Please
Lordship?
come to page 101. This is the first letter, isn't it?
Yes, Lordship.
To
This
DRC.
is the first.
They've raised their claim.
Yes, they have raised the claim subsequently from Your Lordship.
So DRC has to.
Yes,
issue
Lordship.
notice.
They have sent a letter for place their grievance before DRC.
That time, your lordship, we have reconstituted our committee, your lordship. Again, and send him that this is that give your consent that we are new reconstitute our committee because both members from Guwahati, one member should be Silchar. So they have said that no, we are not agree your consent. So we are send our dissenting consent. Thereafter, we again, as they are wish to again we reconstitute our committee and bring all the earlier member, your lordship, and send them, and we are asking them to now you place your grievance. Now, as your wish, we have again reconstitute our committee, and as your wish, again we bring back our earlier member, both from Guwahati, Chief Engineer Guwahati, both member from Guwahati.
No, you have done it.
Yes, lordship.
So chief engineer is already posted with these claims.
Lordship.
So why have they not initiated the proceedings under DRC?
No, they have not yet also placed their grievance, your lordship.
So how? Why will they place? They've already placed at page 102.
Exactly, they have placed before your lordship, your lordship.
After that, what notice have you issued?
From page 102, lordship, 30/11/2022, we have received their letter. That time we have sent a letter. Very next page, your lordship. That we are change our committee because both member from Guwahati region.
We have understood.
Lordship.
Now, when he objected, when he did not give a consent, you rolled it back, went back to the earlier committee.
Yes, lordship.
But the earlier committee, did it assume jurisdiction? Did it proceed to decide on these issues? It did not.
Lordship, thereafter they did not even place their grievance.
Why should they place it again? There, it's already there before the earlier committee. Page 102.
Their grievances that their grievances that you have to bring the earlier member. That time, this is our prerogative, your lordship. This is our prerogatives. Which member? They are not to decide who is member. Who will keep the member of our committee? Who will decide our member, your lordship?
Is it a part of the agreement?
Yes, lordship.
Where is that?
Lordship, page 50, your lordship. Page 50, repetition, clause 25. Page 50.
50.
Yes, 20, clause 25 below, your lordship.
50.
50, Lord, 50. Clause 25, Constitution of Dispute Resolution Committee, serial number, description of DRC, serial number 1, Chairman, Chief Engineer Shillong, Chairman, Section Engineer, W and TLUA RG, and third member, Guwahati. This is the committee of it.
Then what happened?
Thereafter, the lordship, we have reconstituted the committee. One member should be, your lordship, one member should be outside in Guwahati. So we have taken a member from Silchar. So they are objected. They are no, we are not placing our grievance because one member has to be. You are taken a member from Silchar. So if your member again taken you Guwahati, then we'll place our grievance.
Then what happened?
They did not even place their grievance, their lordship.
No, but you said you had gone back to the earlier committee.
Exactly, lordship.
So earlier committee.
My lord, both the parties are bound by the agreement. In agreement, the members of the DRC is mentioned. Once they fail to refer the dispute to the member within the allotted time, they forfeited their right. Subsequently, what happened? They wrote a letter that is not material and that is not valid in the eye of law. Because here it is clearly mentioned. It is signed by both the parties who are the members of the DRC. It is name is notified and they wanted to change. In the meantime, time elapsed. So they cannot take advantage of their own wrong. And as per section 11 also, if they fail to act as required in the agreement, second chance cannot be given. This is well settled law, your lordship knows.
Lordship, may I read the letter, Your Lordship? Annexure 116, Your Lordship.
Page number one.
Page number 116, Annexure 39, Your Lordship. As this is a letter, Your Lordship, issued by Your Lordship, Chief Engineer, Your Lordship, to their petitioners as the agency, GTC India, under their letter dated 23/12/2022, have objected to the composition of DRC. They being not as per the Schedule F of the agreement. That time, this earlier, this new one was not in the mandate of the Your Lordship, earlier agreement, Your Lordship. Hence, the composition of DRC for said agreement issued by this office letter so and so is modified under the accordance with the Schedule F of the agreement, Your Lordship. So again, also we come back to the Lordship on the basis of agreement, Your Lordship, clause F. Your
That's
Lordship.
right. So if it is agreement, then he has written it, they have already written it to the chief engineer. So the chief engineer now being brought back to the DRC is required to assume jurisdiction. Why should he again write a letter? He has already placed the grievance. You decided to alter it and then decided not to alter it. So your time is gone.
This is true.
But present counsel for the parties, this application is filed with the petitioner in the section 11(6). The petitioner was awarded contract.
Lordship, may grant at least 1 week time, at least say, bring some instruction whether they have placed it before the new committee or not, Your Lordship.
1 week.
Just 1 week time.
Counsel for the petitioner, a respondent, pays for a week's time.
My lord, date may be fixed. This is old matter.
1 week.
Date may be fixed.
1 week. 5th December.
5th December.
This is accordingly. Yes.
Lordship, on the last occasion, Lordship, the learned counsel for the respondents had relied upon a judgment from the Honorable Supreme Court as Brahmani River Pellets, wherein Lordship, the term venue was held to be same as the term seal and both were interchangeably used. But Lordship, now Lordship, today I'd like to rely upon a judgment of a 5-judge bench of the Honorable Supreme Court, my lord. The Balco judgment. Lordship, it has been cited, Lordship, in 2012, volume 9 SCC, page number 553. Lordship, I will give you book list.
2012.
9 SCC,
Yes.
page 553.
Page
552, 552.
Balco.
Balco, my lord. Lordship, in this judgment, this is a judgment of a 5-judge bench, Lordship, Honorable Supreme Court. Here, Lordship, distinction has been made between Lordship's sections 20 clause 1, 20 clause 2 pertains to seat and 20 clause 3 pertains to venue, my lord. 5 judgments. Thereafter, my lord,
Which paragraph?
Lordship in paragraph 98 and 99. Lordship, if I may read, Lordship, the last part of paragraph 98, it reads as a plain reading of section 20 leaves no room for doubt that where the place of arbitration is in India, the parties are free to sign to any place or seat within India, be it Delhi, Mumbai, etc. In the absence of parties' agreement thereto, section 20 clause 2 authorizes the tribunal to determine the place of seat of such arbitration. Section 20 clause 3 enables the tribunal to meet at any place for conducting the hearings at the place of convenience in matters such as consultations among its members for hearing witnesses, experts, or the parties. Fixation of the most convenient venue is taken care of by section 20 clause 3. There is a distinction, my lord. And this lordship distinction has been followed in various other judgments. Lordship, now coming to a judgment, Lordship, the Union of India versus Hardy Exploration and Production. This is a 3-judge bench, 2019.
You give a list of,
Lordship, we have judgments.
you have to go through the judgment.
Lordship, this was bulky, therefore I give you the list.
Not a bulky or not, but we'll.
But
see.
Lordship, otherwise we
Send-
have printed out the judgments.
No,
ma'am.
no, that's all right. You don't have to print out. You give us a list. We'll take
Okay.
the prints,
So, Lordship, we have already given a book list also.
including these judgments.
No, these Lordship separately because we've already printed them out, therefore, Lordship.
All right.
Lordship, now coming to this judgment 2019, volume 13, SEC 472, my lord. Here, Lordship, the arbitration agreement between the parties specified the venue for holding the arbitration sittings by the arbitrators, but did not specify the seat. In that context, my lord, if I may come to paragraph 32 of this judgment. Here, paragraph 32 reads as, in the present case, the place of arbitration was to be agreed upon between the parties. It had not been agreed upon, and in case of failure of agreement, the arbitral tribunal is required to determine the same, taking into consideration the convenience of the parties. Here, Lordship, this clause is categorical, because in this case, in this facts, Lordship, the sittings at various places were relatable only to venue. The Supreme Court has held, my lord. And it has to be determined by the arbitral tribunal specifically. And Lordship, in the last paragraph, that is paragraph 35, the court has held, Lordship, taken a view that there has been no adjudication and expression of an opinion. The word place cannot be used as seat. To elaborate, a venue can become a seat if something else is added to it as a concomitant. But a place, unlike seat, at least as is seen in the contract, can become seat if one of the conditions precedents is satisfied. It does not ipso facto assume the status of seat. This is a 3-judge bench of the Honorable Supreme Court. Venue cannot be ipso facto, Lordship, assumed to be that of the status of a seat, my lord. Therefore, Lordship, since there is a Lordship confusion whether seat is also, Lordship, whether seat and venue are two same terms, no, Lordship. Seat and venue are two very different terms. And the same has been
Paragraph 34.
34, Lordship, talks about determination. Determination of the seat by the arbitral tribunal. It has to be categorically determined by the tribunal. And 35 seat does not ipso facto assume the status of seat, Lordship. Unless there is some other concomitant, which in our agreement, there was no other concomitant.
No, this determination is okay. Here, the question is, you see, if there is no objection to the jurisdiction of the court, we can leave it to the arbitrator after
Lordship.
constituting to decide what would be the seat and venue of the arbitration.
Lordship.
But their objection is where it is already decided that the venue.
Yes.
Venue is in Delhi or Noida.
Noida.
It is equal to the seat, and therefore it is that principal court of which will have jurisdiction over that area. Who is the authorized? Who is the court who has been given the jurisdiction to appoint an arbitrator or constitute an arbitral tribunal under section 11(6).
Subsequent to that judgment, Lordship, the judgment which was relied upon by the respondents was decided on July 25, 2019.
Subsequent to that, Lordship, another judgment of the Honorable Supreme Court, Ravi Ranjan Developers versus Aditya Kumar Chatterjee. This was decided on March 24, 2022, Lordship.
Is it
Here-
reported?
Lordship, it's reported 2022 SCC online, SC page 568. Lordship, we have a copy. also.
2022 SCC.
Online, SC 568.
568
Lordship.
paragraph.
Lordship, paragraphs, Lordship, specifically for 11 application is paragraphs 26, 27, and 28. And thereafter, Lordship, I'll read the paragraphs, Lordship.
Yes.
Here, Lordship, if I may read paragraph 26, Lordship, the law has been laid down. Under section 11(6), an application for appointment of an arbitrator necessarily has to be moved in the High Court, irrespective of whether the High Court has the jurisdiction to decide the suit in respect of the subject matter of arbitration, and irrespective of whether the High Court at all has original jurisdiction to entertain and decide suits. As such, the definition of section 2(1)(e) of the Arbitration and Conciliation Act would not be applicable in the case of a High Court exercising jurisdiction under section 11(6) of the Act to appoint an arbitrator, arbitral tribunal. In the next paragraph, which has been stated, at the same time, an application under section 11(6) of the Arbitration and Conciliation Act for appointment of an arbitrator or arbitral tribunal cannot be moved in any High Court in India, irrespective of its territorial jurisdiction. Section 11(6) of the Arbitration and Conciliation Act has to be harmoniously read with section 2(1)(e) of the Act and construed to mean a High Court which exercises superintendence or supervisory jurisdiction over a court within the meaning of section 2(1)(e) of the Arbitration and Conciliation Act. It could never have been the intention of section 11(6) of the Act that arbitration proceedings should be initiated in any High Court, irrespective of whether the respondent resided or carried on business within the jurisdiction of that High Court, and irrespective of whether any part of the cause of action arose within the jurisdiction of that court, to put an opponent at a disadvantage and steal a march over the opponent. Now coming to Lordship, paragraph 43 of the same.
Same judgment.
Same judgment, my lord. This court has perused the development agreement. The contention of the respondent in the affidavit in opposition that the parties to the arbitration had agreed to submit to the jurisdiction of Calcutta High Court is not correct. The parties to the arbitration agreement only agreed that the sittings of the arbitral tribunal would be in Kolkata. Kolkata was a venue for holding the sittings of the arbitral tribunal. In Union of India versus Hardy Exploration, a three-judge bench of this court held that the sittings at various places are relatable to venue. It cannot be equated with the seat of arbitration or place of arbitration, which has a different connotation. In Mankastu Impex Private Limited versus Air Visual, a three-judge bench of which one of us was a member held that the seat of arbitration is a vital aspect of any arbitration proceeding. Significance of the seat of arbitration is that it determines the applicable law when deciding the arbitration proceedings, and arbitration procedure as well as judicial review over the arbitration award. This citus is not just about where an institution is based or where the hearings will be held, but it is all about which court would have supervisory power over the arbitration proceedings. It is well settled that seat of arbitration and venue of arbitration cannot be used interchangeably. It has also been established that mere expression place of arbitration cannot be the basis to determine the intention of the parties that they have been intended that place as the seat of arbitration. Intention of parties should be determined from other clauses in the agreement and conduct of the parties. Here, Lordship, since Lordship, paragraph 25, 26, 27 answers our question, my lord. For section 11 application, Lordship, section 2(1)(e) of the Arbitration Act has to be, Lordship, read.
20?
Section 2, clause 1, clause E of the Arbitration Act, which defines a court, my lord. And now, Lordship, relying on this judgment, Lordship, there's a judge.
Where is this judgment? Para 44.
Lordship.
There is another judgment referred.
Lordship,
This is the judgment that 2019 judgment.
Lordship.
Okay.
This is also a three-judge bench judgment. Lordship, it is a 2020 judgment, my lord. Here also in this judgment, in Mankastu in paragraph 20, Lordship, this Lordship given that well settled that seat of arbitration and venue of arbitration cannot be used interchangeably, Lordship. Three-judge bench, my lord. Now, Lordship, relying upon this, Lordship, now this judgment, Ravi Ranjan Developers, Lordship, still holds field because this is the latest judgment regarding a section 11 application. Lordship, the same has also been, Lordship, relied, Lordship, by the Delhi High Court, Lordship, which had already, Lordship, presented before Lordship, King's Chariot, my lord. Wherein, Lordship, this judgment has been relied upon. And Lordship, here the Delhi High Court, Lordship, held that section 21E has to be construed, as well as, Lordship, for determining the jurisdiction, Lordship, in the section 11 petition, Lordship, section 16 to 20 of the CPC has to be taken recourse of, Lordship, which is either, Lordship, where the defendant normally resides or where part cause of action arises. In that context, Lordship, under this jurisdiction of this Guwahati High Court, part cause of action has taken place, Lordship. Therefore, Lordship, this court has the jurisdiction to enter in this petition, my lord.
No, we'll come back at 2. Or some other day. Because some more judgments have been.
My lord, all these things have been answered in a subsequent decision of the Supreme Court. She has referred to Hardy and she has referred to Balco. Balco has been explained in BGS Soma. That is a 3-judge bench decision, and BGS Soma has been later followed in later judgments. Basically, my lord, it is this principle of Sashua principle which has been relied on there, based on which, my lord, the question has to be decided.
No, therefore,
And that Sashua principle is well laid down in that BGS Soma judgment, which has been subsequently followed. Ultimately, the test is this, my lord, in my understanding.
You have not referred to the judgment.
Well, lord, since here on the other day I was thought of placing, but your lordship required the petitioner's counsel to present it. So the basic test is this, my lord. If there are contrary indication in the agreement, in that case, venue cannot be regarded as the seat. But unless there is a contrary indication given in the agreement, then venue is equal to seat. That is
what is the indication here?
It is venue. There is no contrary indication given here. And that is why I submitted Brahmani River College. Your lordship takes up today, my lord. In that case, BGS Soma,
We'll take it up on next Tuesday. Coming Tuesday.
26th. 25th.
Not 25th.
Yes.
List so for further hearing on 25th. Does it require a hearing?
This is section 11 application.
Any objections?
My lord.
Any objections?
Yes, my lord.
You filed your
Yes, my
objections?
We have filed our objection, my lord. And my lord, they have filed a reply to the also.
This will require some hearing.
My lord. I think if the other side, because this matter has already been decided by the other bench, my lord. The same NIT arbitrator has been appointed and arbitration is running. It is arising out of.
My lord, that is the precise point, my lord. We are objecting, my lord.
Then let us have it on 25th.
My-
25th, if the pleadings are complete.